Your Honor, thank you.
All right. This is a time set for oral argument in Hovannisian, and I'll be delighted to be corrected by counsel during oral argument. Our case number CV19 0385FC. Counsel, we have had an opportunity to review the briefs and the record. We've conferenced the case. We'd encourage you to keep that in mind. Each side has 20 minutes. Mr. Berkshire, if you wish to reserve a portion of that time for rebuttal, you're free to do so, but you will need to keep track of that time, and I will do the same as well. Proceedings are being recorded. We have some court staff who are in the audience as well. And I would ask, as you proceed, that you start by telling us your name and the proper name of, or proper pronunciation for the party that you represent. Mr. Berkshire.
Thank you, Judge. May it please the Court, Keith Berkshire for Hovannisian, who is the appellant in this matter. This is rather unique doing it this way. So I'm going to start with the domestic violence issue, which is the first issue that we raised in our briefing. In this case, I think one of the main issues here is that after this case was decided, your court decided the DeLuna case, which has clarified an issue that's existed, or a misunderstanding or misapplication of 2540303 that I think has existed for quite a while in the trial court level. And in DeLuna, Division 1 found that there was a distinction of this rebuttable presumption under 40303. Specifically, you found that if there was a finding of significant domestic violence or a significant history of domestic violence, essentially joint custody cannot be awarded. However, specifically, your court found that a finding of any domestic violence as defined by the statute created a presumption against the award of sole or joint decision making. Now, that's been a misinterpretation by the trial court for a long time, where trial courts thought that you had to have the finding of significant domestic violence, not just a finding of domestic violence. And here this is applicable because there was an order of protection upheld. And the order of protection obviously requires the same standard for domestic violence. I think when this is looked at with you, when you have an order of protection upheld already, and in light of another case from your court last summer, the Vera v. Rogers case, which is the one hearing rule case for temporary orders hearings versus order protections, when you combine those two cases together, if you have an order of protection that found domestic violence, which here the recordings, the 80+ recordings over 2 years that father did of my client without her knowledge, that which was the ground for the order of protection being upheld, that necessarily under Vera and DeLuna then is a finding of domestic violence in the case, which then creates the rebuttable presumption. And under your DeLuna case, once you have that finding of domestic violence, the trial court has to specifically make findings on the record regarding the rebuttal under 2540303, which did not happen here. The court did not properly apply that rebuttable presumption. They didn't apply a presumption at all. They simply found that the domestic violence wasn't significant and therefore just did a standard 25403A custody analysis. So the error we contend is that now, based on DeLuna, which again came out after, that the trial court was obligated to put the burden on husband to show through the rebuttal portion of 2540303 that joint legal decision making should be awarded.
Counsel, I realize the case came out afterward, but did you make that argument anyway to the court?
Well, the trial court, definitely the argument was made that the order of protection is binding and that there is a domestic violence finding. There was specifically in the, I don't know if I want to call it the closing arguments of the trial. I mean, this was a standard 3-hour trial. There was discussion of how this presumption should apply and how it was on them to rebut it. So there definitely was discussion of counsel and so forth on that. It was obviously pled. They discussed, the transcript and what the order of protection judge found on this as well. So I believe it was easily sufficiently raised at the trial court level based on the domestic violence.
So your position is then that if there is currently significant domestic violence, joint LDM is impossible. If there was in the past substantial or significant domestic violence, joint LDM is prohibited. If there's any evidence of domestic violence, a whole series of findings is required. Is that a fair statement?
Close. I think the first two prongs you said, Judge Swan, I'd agree with under DeLuna. I think that's what your court held, was that if there's a significant history or a finding of significant, that joint LDM is gone. There still has to be a finding of domestic violence to then apply 25-40303. But here there was a finding in the Order of Protection Court of domestic violence. So I think that is essentially res judicata into the family court, especially in light of Vera v. Rogers, which found that you can't litigate this twice.
But I don't know if res judicata gets you there, because right now we're operating under an abuse of discretion standard. And as I read what the judge actually said, I think it's fair to distill it down to, yeah, there was domestic violence, so we're past the point of res judicata mattering. And then this judge added his own impression that it just wasn't that big a deal. And I'm not saying that I agree with that, but that's how I read it.
I'd agree that that's what the trial judge basically surmised or held in the trial, was that he didn't find it to be significant and went through a various series of things about that there was no physical abuse, there was no things like that. But again, under the DeLuna case, a finding of domestic violence requires at least written findings of the rebuttal criteria under 25-40303. So that is the error, and it's the same error that, I mean, it's different than DeLuna, obviously, because DeLuna found significant domestic violence, but there was a finding of domestic violence, which then should have shifted the burden and made the trial court do the specific written findings on those rebuttal criteria. That's what we believe the error was, that burden didn't shift. I mean, this has always been a issue in interpreting 40303 about when did the burden shift? Was it only on significant domestic violence or a finding of domestic violence? Which the finding here was of domestic violence, not of significant. I mean, we argued in our brief that 80 recordings should be at least a significant history of, because I'm not sure how many you need to be significant other than 80, surreptitious recordings.
So are you taking the position then that we should hold as a matter of law that joint LDM was just out of the question on this record?
You found that the 80 recordings was significant, then yes, but our initial
position to make that finding?
Judge?
As an appellate court, are we in a position to make such a finding?
I think you could find that those are harassing actions, and therefore 80 of them meets the definition of a significant number. But I mean, the bigger issue is simply that a finding of domestic violence requires at least the examination and written findings about whether it was rebutted. That you have to at least apply the rebuttal criteria and make written findings on it based on the DeLuna case.
So what happens? What is the remedy? Is remanded for those findings?
I mean, like most custody appeals, I guess I rarely see something other than remand for proper application of the statute. I mean, I can't say I really see, absent DeLuna, which I guess is an exception to that, and to the instruction that the burden be shifted the statute, and if the court is going to award joint, that it would have to go to the criteria and make written findings on the rebuttal criteria.
Thank you.
Okay. The next issue I want to discuss was I'll call it the SEC issue, which was obviously husband hacking into my client's computer. That all the testimony supported that she knew nothing about this. Then did the insider trading with his dad and his friend, which resulted in husband having to borrow between the loan to his father and all the SEC lawyer cost to my client. Roughly was about $170,000, which the trial court equally divided between the two parties. Now, this argued based on either a waste claim or just that it shouldn't be a community debt because there was no community benefit here. Now, what the trial court found, which
it didn't work, right? I mean, if the scheme had worked, there would have been a community benefit, however improper.
Well, that assumes that husband never had any intention to share the money with my client.
No, it doesn't. People in marital communities conceal money from each other and don't share it all the time. That's legal.
Well, but what if even husband didn't get the money? He didn't have the money. It was with his dad and his friend.
No, so, but it was an attempt to engage in a profit-making enterprise. That enterprise happened to be illegal, but we don't hold that illegality prevents gains from becoming the property of the community.
I understand, Judge, but this is more like essentially the case. I mean, what essentially was her benefit here? The trial court held that her lack of losing her job was the benefit. I mean, this is not. I mean,
I don't agree with that, but I think I mean, correct me if you have a case to the contrary, but it seems to me that the proper analysis is what the activity would have yielded if it was completed. So if husband is on his way to make an illegal trade that would have clearly gone into the community bank account and gets into a car accident, that liability is a community liability. And if he makes the illegal trade and makes $1 billion, that $1 billion is the community's $1 billion until somebody proves that it was illegal. Is that not right?
Again, here, husband never actually got the money. This was illegal trades through his friends, and and again, I think the analysis is more like the Helen case. This court found that basically they didn't prove the value would have gone down, but it implied that if it would have, then the community would have had a claim. I mean, what husband did here was potentially cost my client her job and her career even. And I mean, I guess I failed to see how they could be any benefit to my client of me doing this behind her back to her detriment. I mean, it's like saying the community could benefit because husband cut out one of her kidneys at night and sold it on the black market, that was a benefit. I mean,
well, I think a closer analogy might be you're married to your law partner and you commit ethical violations, but they're very profitable. Isn't that a closer analogy?
That I guess you could potentially destroy your partner's spouse's career with.
Well, yeah, I mean, your spouse's career could be ruined. Your spouse could exculpate herself, as happened here, and maintain her license, or you could get away scot-free and keep all the money. And from a community property standpoint, it seems that all of those possibilities are community possibilities.
Well, I think there's a difference, Your Honor, between the fact of going specifically contrary to your spouse to profit and stealing $20 out of a third party's wallet. This is your potential to profit from this only comes from the detriment of the spouse. I mean, you're defeating the community by doing this. The purpose of the community is that a joint effort or joint reward. If I go out and just steal money from a third party that has no potential downside to my spouse versus taking specifically from them, this is an action against your spouse for profit, not against a third party.
If you rob a Circle K and go to prison, it's going to be very detrimental to your spouse, to your children, the entire marital community will be shaken because you committed that crime. But that doesn't mean that the gains from that crime are not community gains, or that the liabilities from that crime are not community liabilities, does it?
And if you lose your law practice in that example because of it, you then committed marital waste because you did something that wasted a community. It was an excessive abnormal expenditure or detriment to the community. So what he did was cause waste. That's the argument here, is that the $170,000 that was spent was waste. The same as if I did any number of actions that caused, I decided to light fireworks inside my house and burnt the house down. That's waste the same way, because what you did was cause a detriment to the community because of your actions. So essentially caused waste. This wasn't an asset they acquired.
What if without the knowledge of the other spouse, you start a business venture completely legally that's very expensive and fails badly quickly? Is that waste?
The lines of waste can be, aren't the most distinct, but I think that the criminal aspect of it, I think it's the same thing of gambling, other things like that are anything that basically is to the detriment of the community, I think can be classified as waste under our case law. And I think here, specifically when it's directly contrary to your spouse, I mean, this isn't something that is to a third party. This is, you did something specifically contrary to your spouse. I mean, that resulted in the waste. His actions caused the detriment. It defeated the community. The idea is a independent benefit to the community about the business venture. Those are potential independent benefit. They weren't directly contrary to the spouse's best interest. I want to move on to the idea of the bonuses and the rental properties. I think the rental property issue was very direct from our briefing. Was the pretrial and the testimony taken for father's positions were that if they didn't agree to the values, he stated specifically, if the judge doesn't agree to the values or Connie doesn't agree to the values, what do you want to do with them? That his statement was sell them. His argument in the pretrial was sell the rental properties. So my client, based on Leathers or Ammer, a multitude of other cases about notice pleadings, his position taken at trial was sell the rental properties if Connie doesn't agree to the values, which she did not. The court stated that my client had somehow agreed to these values because she listed them with a footnote in her RMC statement about the values that she had taken off husband's discovery, saying here's values subject to verification. Husband's trial position was that the rental properties should be sold if they don't agree to the values. That was the position that my client took, was she didn't agree to the values. And therefore, I mean, again, if you have a pretrial, you limit what you testify about based on the other party's positioning. And in this case, the positioning was both parties essentially took the position that the rental properties should be sold because they didn't have an agreement on the value. The retention bonus for my client, it was undisputed. Exhibit 103 from her business said here was the date that the retention bonus was given. It was after the date of service. There was a letter that had the date the retention bonus was given after the date of service. And on top of that, it had a 2-year vesting schedule. So if my client didn't stay there for the 2 years, it's like stock options. She would not have received the retention bonus. So first off, 25-211, 25-213, and the Garrett case, anything granted after the date of service is statutorily separate property, and the court's without jurisdiction to award separate property granted after the date of service. Secondarily, even if these had some community component, you'd have to analyze them the same as a stock option, that it wasn't dollars day one. It's the same as the Garrett case on contingency fees that were earned before and after marriage. So it'd have to be some percentage calculation like we do under the Brebaugh case for stock options. So at minimum, it would be that. But uncontroverted testimony and evidence shows that these were not given to her. Given the SC issues caused by husband, she did not get a retention bonus or was not granted one with a vesting schedule in 2016. It was granted in 2017, and therefore it was outside of the community at all. Which again, the letter from the company shows that very clearly in it. But again, secondarily, even if it was, there should still be at least some sort of calculation of a percentage, because I mean, if it was, let's say it was, the court is right and it was granted in 16, then still only less than half of it would have been during the marriage. And so at most he'd be entitled to 25%, not 50%. Now, lastly, because I'm running out of time, was the child support issue. Here, the uncontroverted that husband had worked in restaurant industry, and between that and his Rooney, I forget the pronunciation on that business, he was making about $150,000 a year. Here, the court attributed to him his business income, which is all passive, and potentially just minimum wage. I don't even know where the calculation frankly came from because I can't calculate it out, but far less than what his historic income was. His argument is that, hey, I wanted to have more parenting time, so therefore I quit my career. Could you imagine if a pilot or a neurosurgeon or anybody else that has a career, a fireman or anybody that has a career, somebody in the military has a career that interferes with parenting time, being able to quit without application of the Little test? I mean, Little says flat out, if you are reducing your income for some purpose, you have to analyze it. What's the harm to the children? The 5-point test said a Little. The court did just, husband had all this separate income from a business standpoint, but didn't impute him anywhere to his historic earnings were, which we believe was error. I mean, I calculated out that court attributed him about $2,000 a month roughly in additional income, or $80,000 he was making historically in restaurants. Again, with a degree in that field, the court didn't attribute any of the income related to his career from his historic income, which was unquestioned, into the child support calculation, which we believe was error. The 2 extra children issue had been resolved at the trial court, so that doesn't need to be remanded on that, where the court gave him 2 kids he didn't have in the child support worksheet. That issue has been resolved at the trial court level. I'll save, I don't know if I have time left or not.
Very little, yes. Thank you, Mr. Berkshire. Ms. Hamilton.
Thank you, Your Honor. May it please the court, my name is Christina Hamilton and I represent Damon Hovannisian. Your Honors, I would ask that all the issues on appeal be denied because, for one, with the exception of one issue, which is the character of the retention bonus, all of the other ones are based upon an abuse of discretion standard, and there was evidence in the trial court that would support all of the decisions that are now on appeal. Number 2, many of the claims that are being addressed on appeal either were not presented at the trial court or were not a part of the pretrial statement, or both. For example, there was nothing about the Fidelity account having a pre and post contribution or appreciation or some aspect that would be segregated out to wife. In fact, if you look in the pretrial statement itself, she divides the account and puts half of the number in her column and half of the number in husband's column on the Fidelity account. There was never any information or anything provided at the time of trial with regard to character of separate or community property as far as the personal property that were on the schedules. There was no issue of apportionment of the bonus, which is what Mr. Berkshire was just talking about as far as the Brebois or Garrett type of analysis. There was no evidence at all of any of that, nor was it in their pretrial position statements. So we would ask that all of the issues be denied on appeal. With regard to going to the specifics now, I'll take them as Mr. Berkshire took them. With regard to the joint legal decision making, the findings were clear that there was never any physical assault, that mom agreed that they could make decisions with regard to the children together, and there had never been any disagreement. She never, in the pretrial position statement or at trial, said she had any, quote, safety issues. It was 100% that she didn't trust him, which was her basis for wanting.
Are you suggesting that this pattern of conduct in which he engaged is merely creepy and doesn't constitute domestic violence?
Well, I don't know that it. Let me say it this way. The Order of Protection Court held that there was either a demonstration of committing it or it might be committed.
Might be. Did it 8 times. It's criminal every time. It's a criminal act directed against her, and the court found it was domestic violence. I'm struggling to see how we minimize this.
Well, I think we minimize it by looking number first at DeLuna and number 2 at 403.03, which are talking about safety issues. Safety issues don't have anything to do with making recordings in his own bedroom of conversations. So it has nothing to do with the children whatsoever. The parties agreed to 50-50 access, so obviously safety is not an issue. Mom admitted there was no finding of domestic violence in her appellate brief.
There was
So
a finding of domestic violence, though. I mean,
in the
there was
order of
one.
protection court.
Yes, but there was also an acknowledgement by the trial judge that there had been domestic violence. He didn't. The court didn't think it was substantial.
Correct.
In the court's word, but there's uniform agreement that there's been domestic violence, and I see nothing in 403.03 that says that safety is the Rosetta Stone. It's certainly an important factor, but it's not necessary. Otherwise, we would be saying that really the Order of Protection Court erred, and none of this stuff was domestic violence. It was merely criminal conduct in the air.
Well,
for which your client wasn't charged, which seems to be, frankly, a bit of a pattern here. I mean, he wasn't charged with a crime by the SEC. He wasn't charged with a crime for the surreptitious recording, but every time it has other ramifications. And it sounds like you're saying that the pattern of conduct here should have absolutely no bearing on the case, which is a stretch for me.
Well, I have a hard time stretching it to this case, Your Honor, in all due respect, because we're talking about children. We're talking about the fact that the statute says that it is the public policy of the state that parents have mutual involvement in decision-making with regard to the children, and there was not one scintilla of evidence that anything that happened with regard to the recordings had anything to do with the children or anything to do with the parenting time or decision-making. And all the other aspects with regard to 50-50 access.
So if he commits physical domestic violence in private, has nothing to do with the children, that's okay?
No, but then there would be an issue of safety for the victim.
In this case, it sounds to me like you're basically saying, absent a threat to safety, absent a physical act, 40303 is gone. All that verbiage in 40303, that carefully crafted language, we can distill to its essence to say, as long as you don't hit somebody, you're good.
It's not as quite as simple as that, but at least it is a.
Tell me where.
Well, excuse me. Yeah, it's a presentation of. We have to look at the whole situation. I'm sorry.
I'd appreciate it if I could get the questions out, and I'm sorry if I interrupt you, but that's kind of the nature of the enterprise. So I would like to know what part of my analysis of your argument as it relates to 40303 is wrong, because I'm not seeing any area in which you would concede that the statute applies without an actual threat to physical safety. I don't get that from the statutory language. So help.
Okay. So in the statutory language, I think that they're looking for issues of domestic violence that pertain toward the child. It says domestic violence and child abuse. If there is a finding, such as in this case, of harassment, does that then cause him to be a bad parent, not have access to making decisions with regard to his child? At best.
That seems to be the determination that the legislature made when it passed the statute. But
So at best,
to go through the text of the statute rather than ethereal considerations about whether he's a good parent.
Okay. So if at best, if Mr. Berkshire is reading D, and maybe that's what DeLuna is supposed to say if there's any specific act of domestic violence, then we have to go to paragraph E. This is just having the remand so that the court can make these findings, none of which apply in this case. Number one is whether the parent has demonstrated that being awarded sole or joint legal decision-making is in the child's best interest. The court found that it was. Number two, whether the parent has successfully completed a batterer's prevention program, never even was on the table. Number three, whether the parent has successfully completed a program of alcohol or drug abuse counseling, again, never an issue, never on the table. Number four, whether the parent has successfully completed a parenting class, if the court determines that a parenting class is appropriate. Other than the normal parenting class, the court did not order any additional parenting class. 5, if a parent is on probation, parole, or community supervision, whether the parent is restrained by a protective order that was granted after a hearing. He was never on probation, parole, or community supervision. 6, whether the parent has committed any further acts of domestic violence. There was never any further act of domestic violence.
Well, I'm sorry. There were 80 of them.
Over an extended period of time, right?
There were 80 conversations that he had transcribed or recorded, yes. But the court found that that had not, in comparison to all of the things that had been going on as far as 50-50 time, no physical assault, no anything, that was not sufficient to keep him from joint legal decision making. And in fact, Mother had put in her resolution management conference statement that there should be joint legal decision making, and only after she found out about the conversations did she then change her mind. I'd like to go on to the other issues, if I may. With regard to the SEC debt, it was a community debt. There's no question that it was incurred during the course of the marriage. 25214B gives a husband the ability to bind the community. Wife was benefited in not losing your job. I want the court to understand the husband never was convicted or pled guilty. The community had, to date of the trial, and to this date still, not paid any of the $155,000. And wife is suing husband and had been suing husband in a separate civil action throughout the divorce case, in which Judge Whitehead said in the divorce case, look, if that's deemed to be some level of damage in the civil case, I'm not telling you you can't be awarded it there. All I'm saying is it's a community debt, and I need to allocate it as a community debt. And to your point, Judge Swan, there were other issues in the case about the fact that husband recreationally gambled, and yeah, when he won big, she loved it. So if this is just sort of another form of, if you're going to go into an enterprise, she would have benefited from it. So why isn't the liability equally a community liability? With regard to the retention bonus, the disclosure statement of Mother from the civil case was read into the record, and in Mother's disclosure statement, it said, in addition to not being allowed to participate in projects that required a non-disclosure agreement, Mrs. Hovannisian was also informed that a retention contract with the company had been on hold from July 2016 to October 2017, pending the outcome of the SEC investigation. Thus, on her own disclosure statement, she was saying it was a bonus that was to be awarded in 2016, but had been kept on hold. That being the case, it was, quote, earned during the course of the marriage. And the judge said that similarly, because it was a set amount of money, $95,000, didn't matter what happened, it was going to be $95,000 as long as she stayed there till the end date. The court said, I think that they both run the risk of her leaving the company. If she leaves, they get nothing. If she stays, they both share the benefit of the bonus.
Yeah,
and
but all of that is post-dissolution, right?
Her staying at the company, yes.
Right. So I'm struggling to find how the community has any interest in her future labors.
The retention agreement doesn't say anything about, quote, future labors other than staying there. It doesn't say like she has to meet certain targets or anything like that. Just
presumably
says she has to be there.
Yeah, presumably she's got to come to work, and they know her well enough to think that she'll do a good job, right?
Right.
Okay. So, and if she doesn't come to work, she doesn't get the money. And all that happens post-dissolution. Why isn't that the clearest cut case of sole and separate income there is?
Well, liken it to either a restricted stock or a stock option of some kind. You've earned it back here in the marriage. You're just waiting for it to come to you.
But the condition is that you have to show up and do the work.
True, but there was no demonstration at the time of trial that this amount of work was needed to keep the bonus, or these days were somehow to be put in a calculation of some kind on dividing up the bonus. It was simply...
We're not talking about a quantitative measurement. We're only talking about a binary choice. Was it community or not? And that's a matter of timing, right?
It's a matter of timing as far as when it was earned, and it was earned during the course of the marriage. She just had to wait for it. She was still getting compensated for being there and doing her job. That's her salary. She was just waiting for the bonus to be paid, which was already predefined as $95,000, and it was just a matter of her waiting out the term.
What if she had gotten a raise effective the day before the decree, and then continued to receive it after the decree. Should her income be shared with the community? I mean, she got this raise. All that's necessary is that she go to work and collect her paycheck for the next few years. Is that something that husbands should share too?
Not other than in spousal maintenance or child support, no.
Okay.
But again, that's not what this was. This was a bonus that had been awarded to her at $95,000. Just wait for it. The father's income on child support, mother was very vocal throughout the course of the proceedings that she was going to use well, first of all, father was in the restaurant business. Father's restaurant closed. He didn't voluntarily terminate. It closed. Now father's out of a job. Mother was then very vocal that she was going to use that to take the children and not allow him to have 50-50 time. The court found that using the $94,000 for father's income was appropriate because he was going to have to move into a different form of employment, that mother was using the children against him. The Little case says specifically that the court is supposed to consider the reasonableness of the parent being unemployed or underemployed and the impact on the children.
It sounds though like you're making the argument that because he's kind of got a nice passive gig, and the judge found that it was, I forget, a comfortable living or something like that, that he just doesn't have to work, which would be a really novel standard if applied to other cases.
I'm not making that argument, Your Honor. I'm making the argument that at the time of the trial, that's where he was in his life. And at that point in time, the judge said, okay, well, I'm going to attribute some income to you, but I'm not going to attribute your restaurant income to you. So at that minute in time, that's what he was. Now, years later, could he argue, or could mother argue that by now he should have gotten into a better employment situation? Yeah, I think they could. But that's not what it was at the time of trial.
I'm sorry, but if I don't power this laptop, I won't hear anything you say.
Okay. As far as the rental properties are concerned, I frankly don't understand mother's positions. The father in his pretrial position statement said, look, either award mom the house and award me the rental properties and we'll do the math to equalize, or sell everything. The court then, in the trial court, in the decree said, Mom, you have the choice. You can either sell the house or you can buy him out. Dad, you can either buy her out of the rental properties or we can sell everything. Mom chose to buy him out of the house. She didn't have to. That was a choice she had. Dad chose to use or to buy her out of the rentals. The rentals, until the day of the pretrial statement, there was never any information or disclosure of any kind to any values other than what mother had put in her resolution management conference statement, which were the identical values that the court used and were the identical values that husband had submitted to the court as his opinion of value. There was no other evidence of any kind at the trial of a different value of those properties. So for fathers simply saying that's what the court ordered the equity to be, I'm willing to be bought out of the house, I want to buy the rentals, and that netted out to about $44,000 that mother owed to him. As far as the fidelity account, again, there was zero evidence of any pre or post contribution. And in fact, I think if you look at the pretrial statement on page 11 of mother's pretrial statement, she has columns and she's divided the value equally in both of those columns. Further, I think in the transcript on page 24, they first were talking about the Ford plan. Mr. Rose then did say the word fidelity, but then on page 26 of the transcript, they agreed to a division, not an equal division of the Ford plan, which is what they were really talking about. As far as the award of $30,000 of attorney's fees to father, the court found not only did she have the greater financial resources, but that she took multiple unreasonable positions. There were 8 different positions that the court found her to be unreasonable upon. Only 2 of them are those on appeal. 6 others were not even addressed on appeal, which the court found to be her to be unreasonable upon. So her argument in her brief that the $30,000 should be reversed because she's shown you now that her positions are reasonable really doesn't address the other 6 bases upon which the court found that she was unreasonable, including her consistent positions that she should receive significantly more than 50% of the estate. She had a $400,000 waste claim that was all denied. She would not allow dad access to the kids until the eve of the temporary orders. And then there were other issues that were listed as far as her being unreasonable. As far as personal property is concerned, again, there is nothing in the record where she was talking about separate property or her wedding rings, etc., as being on the schedules. The court again gave her the opportunity to either take the schedule that father had proposed and do the division of assets that way, or gave father the opportunity to buy the assets on mother's schedule at the values that she identified. So that was a choice that mother could have made, and so that's I don't understand where she's getting any situation where she was somehow taken advantage of in that, because she had the opportunity to choose which one she wanted to do. Finally, we are requesting our attorney's fees for the appeal. Again, as I stated from the beginning, the issues are either all based on abuse of discretion, and there was evidence, number one. Number two, with the exception of the character of the bonus. Number two, there were multiple issues that were addressed on appeal that weren't even addressed at the trial court level or that there was any evidence upon. And three, I think that frankly, if the issue is boiling down to the 25403.03 language, the issue is simply a remand to address the factors in 25403.03E. And again, we went through those earlier. I don't know that any of those are going to be applicable in this situation.
Ms. Hamilton, thank you for your presentation. Mr. Berkshire, I'm going to give you 90 good seconds for rebuttal. I think our time is nearly out already, but go ahead.
Judge, the fidelity account, I mean, you can read the transcript of what we put in there. There was an agreement that just the post and pre-service appreciation, it was an agreement between counsel. They didn't discuss it more, present more evidence, because there was an agreement on it at the trial. The personal property, it's clear, it was the memorabilia and so forth. Issues were literally listed twice. You already have to equalize them plus then give half. If it's in her then and then the amounts, then you don't divide it. The rental properties, to go back to that, that's all spent my time on, was, and you just read the transcript and read the pretrials. It says if you don't agree on the price, both parties wanted them sold. Parties didn't agree on the price. We wanted them sold. It was in the position statement of both parties on that, and I'm assuming I'm out of time.
Thank you, counsel. We appreciate your briefing. We appreciate your argument today, and we appreciate your patience in far less than ideal circumstances. But we will take the matter under advisement, and we'll issue a written ruling in due course. Thank you all.
Thank you, Your Honors. All right, bye-bye.